So I am joined by Jade Gani today. Jade, thank you so much for being on the podcast. It's great to have you here. It would be good if you could just tell us a little bit about your journey, yourself, and your business, Circe.
Yes, so I have been qualified 8 years today. And I did a little bit of time working in property as well as serious crime, and decided that neither of those were for me, and qualified in the area of private client, which is essentially wills and probate, tax and estate planning. It's quite a technical area of law, but it also involves a lot of contact with your clients, which I quite like. I am a director for the Association of Lifetime Lawyers, where we provide training for other solicitors up and down the country. And I am also fully qualified with the Society of Trust and Estate Practitioners. And this just means that I have additional qualifications in very technical areas of this particular law, dealing with older and vulnerable people. I decided 2 years ago that I was going to start my own firm, Circe Law, and that we would create a very inclusive, very healthy working environment for lawyers so that they can fall back in love with law and advocate and innovate for our clients. Law can be a very difficult area to work in. There is still a lot of misogyny. There is still a lot of racial bias within a lot of law firms who are very traditionally focused, shall we say. And so the idea for Circe is to provide that super inclusive environment for them and give people the resources that they need in order to thrive. And we see that because our lawyers genuinely want to go above and beyond for our clients. And we see that in the way that they create new innovations and new services for them as we serve the community.
So Jade, can you tell us a little bit about probate? What is probate to start off with?
So a grant of probate is basically a certificate, and it's similar to a death certificate. And where a death certificate proves that somebody has passed away and the circumstances surrounding that, the grant of probate essentially details who is legally responsible for dealing with somebody's estate, and it gives them the authority to then start drawing in assets and paying beneficiaries and things like that.
Okay. And so do I need probate? Does one need probate?
Not always. Sometimes where there are couples who are married and they leave everything to each other in the first instance and they have nothing but joint assets and joint names, you may not need a grant of probate because those assets may pass via survivorship on the death of the first spouse. But where you have certain assets like stocks and shares, NS&I bonds, if you own property as tenants in common, then you will need to get the grant of probate in order to deal with those assets.
Okay. And so when, let's say I'm involved in, a situation where somebody close to me passes away, what's sort of the first step in the process?
I always say to my clients that the first thing that they need to focus on is arranging the funeral, because I think that's a really important part of the grieving process.
Yeah.
That aside, in the background, if you are instructing a solicitor to help you with the estate, then they can be opening their file, they can be sending out the death certificate to assets and liabilities to gather all the information that you need in order to complete the inheritance tax forms, which will need to go to the revenue. They can also make inquiries about any original wills or other documents that they'll need for the general application to the court as well.
Okay. So you mentioned a few things there, some various forms and IHT and bits and bobs like that. So in terms of gathering information about the assets in an estate, how do you go about that? How do you know what somebody has?
It can be really, really tricky, and certainly with older persons, it may be that because a lot of their assets were gathered in a time where we didn't have the internet easily accessible or even around, some of their assets may be what we class as dormant, and they may have even forgotten that they have them. It could be an old pension. And there's a number of things that you can do. We usually start by looking through any paperwork that they have at home that you may be aware of. Look for old share certificates, for example, or anything with old policy numbers on. Another thing that we could do is undertake an asset search. So there are companies out there that will write out to hordes of assets and liabilities that are on their records just to see if there are any dormant accounts with them.
Okay.
It's not always successful, but I have had occasions where bank accounts, for example, have been found that nobody knew about, and they've had as much as £100,000 in them.
Wow.
So that made an incredible difference to the beneficiaries.
Yeah. Okay. And so what makes a will legitimate? Does it have to be drafted by a solicitor for it to be legitimate? Could I just write on the back of a piece of paper one day, this is what I want to happen when I pass away? Or is that a legitimate will? Or
100%. You could write your will on the back of a napkin. It doesn't have to be drawn by a professional. It's an unregulated activity, which means you don't need a solicitor to prepare a will. But I would recommend that you do. Wording in wills is absolutely paramount to their interpretation. And I have seen cases where just one word has turned the outcome of that case that has been used. And it can be simple things such as referring to your spouse, but then you got divorced and remarried. Which spouse are you referring to, for example? And so it's really important that they're drafted appropriately. And using a solicitor is the best way to do that because they have years and years of qualifications behind them and experience. And ultimately, because they are regulated, if something has gone wrong with the drafting of that will, then their regulators have a huge compensation fund, which can be used to rectify any errors.
That's really helpful. So how long does the probate process take usually?
Oh, this is the golden question. It used to take about 10 days once you sent your application off to get a grant back in the golden days. But due to a series of unfortunate events that happened during COVID and the digitisation of the probate process, unfortunately the courts have not caught up and there is currently a 22-week wait time to obtain the grant of probate. That's after you've spent probably a couple of months collecting in all the asset and liability information you need in the estate. So it's quite a long process.
Right. And what does that mean, that delay then for people, executors, beneficiaries? What does that delay?
The delay can be devastating. We've had property sales that have fallen through because of the delays. We see that beneficiaries are in financial hardship as a result. One other difficulty that they're facing is when it comes to paying for inheritance tax as well, and the interest charges that are applied on any outstanding tax during this whole process. And it's all completely out of their control, so it's really frustrating.
Can we touch on IHT? I know we've spoken about it and mentioned it briefly already, but IHT, so that's inheritance tax. So firstly, how do you calculate that? I mean, that's an open question. We can give examples if we need to, but and how do people pay it? And what are the terms of payment as demanded by HMRC?
Yeah, so everyone has an inheritance tax allowance known as the nil rate band of £325,000 that's super flexible. It doesn't matter what assets you have in your estate or who you leave it to, it just simply applies. There is also an additional allowance known as the residence nil rate band. And this is where a person has an interest in a property that they've lived in as their main residence that they ultimately leave to their lineal descendants, i.e. their children or their grandchildren. If they meet that criteria, they could benefit from an extra £175,000 allowance towards inheritance tax. However, if your estate is worth over £2 million, then for every £2 over that amount, the amount of the residence nil rate band you can claim is tapered off by £1.
I see.
So when we're calculating inheritance tax, we look at the overall sort of net value of the estate, and then we deduct any allowances as well as any reliefs like business property relief or agricultural property relief. And then we come up with the sort of baseline amount that we calculate the tax from. And inheritance tax is currently 40%.
Right. Okay.
Very heavy tax indeed. It should be noted, though, that if you are leaving your assets outright to your spouse on your death, then that will all pass spouse exempt and your allowances won't be impacted and they can be transferred to your surviving spouse.
Understood. Okay. And so what are the terms of payment? So when do HMRC demand that you pay IHT? I think I'm sort of answering the question here a little bit, but let's say that there is an estate with a property in it worth £1 million and that's it. There's nothing else in the estate. Firstly, we assume that inheritance tax is 40% of that. When am I supposed to pay that and how am I supposed to come up with the funds?
This is where we see a catch-22 situation, because in order to sell that property, you need the grant of probate. But in order to get the grant of probate, you have to pay the inheritance tax. So it's being caught between a rock and a hard place. And this is where we're seeing IHT funding coming in quite handy. So where there's just a property in the estate, you can pay that inheritance tax over 10 yearly instalments. But on a property that's worth £1 million, that's still a significant sum that often beneficiaries don't have. Once the property is eventually sold, after you've got the grant, all of the tax is due. And so we're finding that companies like Level are providing an easy and simple solution to needing to pay the inheritance tax before obtaining the grant.
And so how much does obtaining the grant cost?
It's currently a fee of £300 plus £1.50 for every copy of the grant that you need, sealed copy of it. So that's the court fee.
Yeah.
Naturally, if you use a solicitor's firm to help you with that, then there will be costs with them as well. But what I would say is that if there's a chance that any inheritance tax is due, or where you need to claim extra inheritance tax allowances to reduce the tax, it is well worth you instructing a professional to do it, because they will make sure that the maximum allowances and exemptions are claimed.
Understood. Okay. And, this might be a tricky question, especially considering you are a lawyer, but how would you suggest that somebody, needing to embark on this process and needing some advice, how do they go about selecting the right person to help them administer the estate, or to get some advice on how to properly do it?
Yeah, it's an incredibly personal process. Your lawyer is going to be effectively holding your hand through one of the worst times of your life, grieving someone very dear to you. And so it's really important that you get along with that lawyer from a personality perspective, but it's equally important that they are appropriately qualified. So I would suggest that you look at organisations like Lifetime Lawyers, for example, or the Society of Trust and Estate Practitioners. And these are extra qualifications that the lawyers have gone through in this very specific, very niche area, and are essentially the gold standard for this type of work.
Okay, that's really useful. What happens if there is a dispute over the will?
So disputes can arise in many ways. It could be that they're disputing the validity of the will, the capacity of the testator to have made that will. There could be an issue with fraud or undue influence. But most commonly, we see that disappointed beneficiaries, like children, they may feel that they weren't left an adequate amount in the will. And so they make what's known as a family provision claim against the estate. And that is essentially a piece of statute that says that if you are the spouse or partner or child, or treated like a child of the deceased, then it's possible for you to make a claim against the estate if not enough provision has been made for you. So where claims arise, it's really important that you do take out the grant of probate, because that will give you the authority to deal with and respond to any claims. It also starts the clock ticking for any potential claims to be brought forward, because by and large they should be brought within 6 months from the date that the grant is issued.
Okay, understood. And so if you are not a beneficiary, so say that I'm a linear descendant, and I feel that I've been hard done by, I haven't been left anything in a will, how do I go about bringing a claim?
I absolutely would not recommend that you do it yourself. Take specialist legal advice. Private client matters, so wills and probate, are a very niche area, and claims within wills and probate is even more niche. It's like a subset of that area of law, but there are companies that specialise in it. A lot of them offer a free initial consultation, and some even offer a type of no-win, no-fee arrangement depending on the facts of the case.
Okay, that is great. And what documents does somebody need for probate?
In order to obtain the grant of probate, you will need any valid last will that's in place with any codicils potentially. With that, you will need a copy of the death certificate, as well as the completed inheritance tax forms, a signed PA1P or PA1A form, depending on whether or not there is a will or if it's under intestacy. And you'll also need to sign a statement of truth that you make to the court, which essentially says that you're going to behave within the bounds of the law and do what you need to do in your role as an executor.
Understood. Okay. And then I think that nicely brings me on to speaking about executors and their role. So speaking from my personal experience, my mum kindly decided to tell me the day that I am the executor of her estate, having not previously known sort of the onus that has on somebody. I was flattered, but obviously with it comes responsibility. So what is the role of an executor, and what should somebody expect and think about if they find out that they've been made an executor of somebody's estate?
It's a very important role, and depending on the particular aspects of the estate, it can be a very challenging and quite technical role to undertake. Being the executor essentially means that you've been the one chosen to deal with the estate as a whole, and that includes applying for the grant of probate. It includes arranging for any inheritance tax to be paid, arranging for any liabilities in the estate to be settled. It will mean collecting in assets like stocks and shares, or selling property, all of those kinds of things, to essentially draw in the value of the estate and get ready to distribute it all to the beneficiaries. But this role, because of the aspects of it, it can come with a fair amount of liability. For example, are you prepared for the situation where there are stocks and shares in the estate and the value of them dramatically drops at the point in which you were hoping to sell or transfer them to beneficiaries? Are you aware of all of the potential beneficiaries? Has the will named classes of beneficiaries, for example, and has there been perhaps a child out of wedlock that you may not be aware of? Do you know what steps to take in order to protect yourself? And of course, as we've mentioned, there could be potential claims against the estate as well. And I find that where there are executors who are family members and they're also beneficiaries of the will, they really struggle switching between their hats as a beneficiary and their hat as an executor, where you owe a fiduciary duty to all of the beneficiaries, as it were. So your executors should act impartially, and they should be up to the task of dealing with all of these issues. So if they're no good at paperwork, if they're terrible with finances, they're probably not the best person to name as your executors. But of course, where a layperson is appointed as an executor, they always have the option of employing a professional to help them with this process.
So let's say, using me again as an example, I'm an executor and I decide that I want to hand over that responsibility to a professional. How do I go about doing that?
So essentially you become our client and we work on your instructions, and generally solicitors will do as little or as much as you want them to in that matter. So it may be that you feel comfortable filling out bank closure forms, for example, but you don't feel comfortable filling out the much more complicated inheritance tax forms. So you leave that for your solicitor. I have to say that most of the time clients just want to focus on their grief and healing as a family, and so they usually just get me to deal with the whole lot from start to finish. And what that means is we just keep them updated regularly, let them know what the current timescales are, so it just takes the weight off of them and puts the onus on us instead.
Understood. And then does that mean then that you become the executor yourself, or you're advising the executor?
No, we're simply advising the executor. The executor themselves will still have to sign all the paperwork.
Yeah.
That is, of course, unless they really don't want to do it, they can create a power of attorney that appoints somebody else to act on their behalf instead. So on occasion, we have acted as attorneys for the executors and dealt with the administration of the estate.
Okay, understood. And then, going back to right at the beginning of the process, how does somebody obtain a copy of a will?
So this is a tricky question to answer. Wills are confidential documents, and they aren't made public until the grant of probate is applied for, when it then becomes a public document of the court. So if you want to get a copy of the will beforehand, you would need to be one of the executors named in the will to have the right to obtain that, or have the consent of one of the executors to obtain a copy. That being said, it's really important that if you are acting as an executor, the beneficiaries have a right to understand and know their entitlement in full. And so if they're gifted a specific gift, like a fixed sum of money, say £10,000, you should provide them with a copy of the will. You could redact other parts of it, but you would need to demonstrate that they're entitled to that £10,000. Where the beneficiary is a residuary beneficiary, they're actually entitled to more information because what they receive will ultimately be dependent on the whole facts of the matter and how you deal with it as an executor. And so you should provide them with a full copy of the will, as well as full copies of your estate accounts, so that they can see how their entitlement has been calculated.
Okay, understood. And is there a time frame attached to that?
No, some estates could be as quick as sort of 6, 7, 8 months. Other estates I've had have lasted 4 or 5 years. It really does depend on a number of factors, including the complexity of the assets, as well as whether there are any disputes that arise.
Yeah.
Because if a dispute does arise, then naturally the whole process is going to take much longer to resolve.
Yeah. Okay. And what happens if the estate has debts?
It depends on whether or not the estate is solvent or insolvent. Usually the estates are solvent, and that means that we pay the liabilities out of the funds that we receive in the estate. Where an estate is insolvent, i.e. there aren't enough funds to cover all of the liabilities, there is an order of priority when it comes to those liabilities, and it essentially means that the beneficiaries may not receive anything at the end of it.
So the debtors rank ahead of any beneficiaries in an insolvent estate?
They absolutely do.
Understood. Okay. And is there then, say somebody's made an executor of an insolvent estate, is there an onus on the executor to then pay for any existing debts that weren't paid?
The executor has the responsibility of repaying those debts, but they don't have the liability of repaying them. So they don't have to pay those debts out of their own pocket, but they do have to make sure that if the estate has the funds to cover them, then they pay those.
Got it. Okay. And what if there are international assets within an estate?
Things become a lot more complicated. It does depend a little bit on where those international assets are and whether or not the deceased was deemed domiciled here in the UK, because there could be conflicting tax treatments. Some countries we're in a treaty with, which means that effectively you don't get taxed twice in each jurisdiction. But again, it will entirely depend on what assets they are and where they are. Some countries also have forced heirship rules, which will mean that the will may not apply and that the asset has to be passed down in a certain way, for example, to your children or grandchildren. And again, in some of those countries with forced heirship rules, there is even further legislation that will acknowledge a UK will, provided that person was domiciled here in the UK. So it's extremely complicated.
Yeah.
And it would be my recommendation that you get the advice of an appropriately qualified solicitor.
That is really helpful. So Jade, what claims are usually brought in contested cases?
We see a great deal of the family provision claims where someone has been left out of the will. We also see claims for duress or forgery, or a lack of capacity is quite a common one. And this is where ensuring that you use an appropriately qualified professional comes in handy, because they will run through all the tests that they need to do in the background to prove that the person has capacity. They'll meet all of the requirements for validity. They'll ensure that no duress is being placed on the individual, and lots more. They'll also have to talk about the potential claims that any disinherited beneficiaries would have. And so this is all really crucial evidence when it comes to those types of claims.
Okay, fine. And what can a contested probate case cost?
It does depend a lot on the facts of the case and the type of the case, but easily tens of thousands of pounds, upwards of £50,000 if things go to court.
Yeah.
I've seen matters where it's been closer to £100,000 in legal fees. And the issue with this is that they're not always payable from the estate. So if the reason that the matter has gone to court has been because an executor or a trustee has been in breach of their duties, they could be found personally liable to cover the costs. So it's really, really important that before acting as an executor or a trustee of an estate, that you understand the implications of that and seek the right advice.
Okay, understood. And what are common issues that you face when there is more than one executor and or beneficiary?
Warring siblings is something that I've come across a lot, and weirdly it always seems to be 4 sisters or 4 brothers, like not mix. I don't know what it is about that, but when you have executors and trustees, so trustees, for example, they need to make unanimous decisions. So if one trustee dissents or doesn't agree, then you can't make that decision, and that means that you may have to go to court in order to either remove the trustee or get a decision about how the estate needs to be managed. And this can mean that estates drag on for years and years, because getting a court hearing can take several months. And obviously it's unpleasant for the family members. It often ruins those relationships. And so I normally advise clients that not to pick necessarily all of their children just because they want to be treated equally, but to pick the children that they think will stick with the deceased wishes and that won't argue, and get along, and make the decisions that need to be made effectively.
Okay, understood. And can you tell me a little bit about the 7-year rule?
So the 7-year rule relates to lifetime gifting. So it's perfectly possible you can gift whatever you like in whatever manner you like. And provided you meet certain conditions, if you survive 7 years from the date of that gift, it will fall outside of your estate for inheritance tax purposes. However, if you die within that 7-year period, then the value of that gift will be clawed back into your estate for your inheritance tax calculation. And a lot of people aren't aware of this. And I do have some clients who will say to me, well, how will the revenue know? Well, if you're gifting property, then the Land Registry has a record of who had ownership of that property. If they're submitting a self-assessment return, then the revenue have details of what assets are involved in that. And also the revenue can and do request 7 years worth of bank statements, and they will go through and they will ask you to explain any payments more than a couple of £100, and all of that can be clawed back in. Now, obviously, if you're not keeping a good record of those gifts, then it can be extremely time consuming for the professionals to deal with after the fact. So good record keeping is key. And what some of my clients really don't appreciate with the 7-year rule is that whilst they can gift any amounts that they like, the order of those gifts can have an impact on inheritance tax.
Okay.
And so I had a situation again with the 4 warring sisters in an estate where each of the daughters had been gifted a property, but at different times. And so the first daughter, who was gifted a property by her father, the value of that fell below the nil rate band of £325,000.
Oh, okay.
And so she had no tax to pay on that. The second daughter, the value then topped that up over the nil rate band. And so she had some inheritance tax to pay. And then the third and fourth daughters were responsible for paying all of the inheritance tax that was attributable to their gift. So it was a really sort of unfair division, and the sisters would not agree to kind of spread that cost equally between them at all. So it's important that if you're considering estate planning, tax planning, or making gifts, that you do get advice.
Okay.
The other thing about the 7-year rule is that the revenue state, in order for this tax planning initiative to take effect, when you gift something away, you can't retain a benefit in it. And they're particularly vague about what they mean by retaining a benefit. So you can't simply gift your house that you live in to your children and hope that the 7-year rule will apply, because you have retained a benefit by remaining living in that house. If you then paid your children a commercial rent, you may be able to argue that you no longer retain a benefit in that gift. So it gets complicated. And there is case law that suggests things like gifting paintings, how often you have access to enjoy those paintings can impact whether or not they form a true gift. And if you have retained a benefit, it's no longer a potentially exempt transfer subject to the 7-year rule. It then becomes a gift with reservation of benefit. And that means that you could have made that gift 50 years ago, 100 years ago. It's still going to be clawed back into your estate for inheritance tax purposes.
Wow. Okay. And who, forgive me, this is not something that I, do day to day, but who is doing the investigating on behalf of HMRC? Have they got, a team of inheritance spies that are coming?
They do. Essentially, yes. No, they've got a whole team and district valuers and various other things. So not only will they question what assets are in the estate, but they can also question the value of those assets. So some executors will want us to put a lower value of the property, for example, so that they pay less inheritance tax. But that can be kicked to one of their district valuers, who may challenge that, and there can be and back and forth. Equally, it's not always a good thing to reduce that value of the property, because it may be that if you reported the true value, it would still be underneath all of the inheritance tax allowances one has to apply against their estate. But if you put that price lower and then come to sell the property at a higher price, there could then potentially be capital gains tax to pay. So it's honestly best to just report things at their true value.
Yeah. Jade, if people want to contact you, how do people do that?
So the best place to take a look will be on our website. So that's Circe Law, CIRCE law.co.uk. There you will find the whole team's email numbers, telephone numbers, and everything else that you need.
Amazing. Great. Well, Jade, thank you so much for being on the pod. It's been great to have you. And
until next time.
Until next time. And if you were wanting to find out if you're eligible for funding for any of the matters that I've just spoken about, you can contact us through our website or through our phone number, which is 0207 205 2870.